Welcome back to the Big Focus. The Supreme Court is set to hear the matter on the validity of the contentious sedition law today. Meanwhile, in a clear departure from its earlier position, Centre told the Supreme Court that it will re-examine and reconsider the provisions of the law. The Centre also requested the Supreme Court to defer the hearing till that process is complete. In a fresh affidavit, the Centre said that Prime Minister Modi is of the firm view that the baggage of colonial-era laws which outlived their utility must be scrapped. The decision comes just 2 days after it staunchly defended the contentious law and sought dismissal of pleas challenging it. Let's go across to Meenakshi joining us live on this. Meenakshi, what's expected at the court and what's behind the Centre's sudden change in stance?
Well, very quickly, a little background for our viewers. You see, the affidavit which the government had filed on this particular issue had also come up because of the reprimand, or rather, the rap the government had received on an earlier occasion from the Supreme Court, which had questioned as to why is the government taking such a long time to come out with a legally articulate policy as far as sedition is concerned. And we had seen the solicitor inform the Supreme Court that this is an important subject matter and therefore the nod from the competent authority has to come by. Subsequent to that, we had seen that affidavit being filed by the government, which had batted for the retention of the 1962 judgment of the Supreme Court, where the Supreme Court had upheld sedition law in India with certain clauses. And subsequent to that, yesterday, what we saw was this amendment of position being presented before the Supreme Court ahead of the crucial hearing today, where the government, like you rightly mentioned, is now planning, or rather has requested the Supreme Court to defer the hearing on sedition altogether, saying that it is a subject matter for now the Supreme Court should avoid adjudicating on, keep its hands off the issue, because, like you rightly mentioned, the Prime Minister himself is very keen to ensure that all colonial era laws, which no longer serve any purpose or utility, should be scrapped. And therefore, in that backdrop, the Government of India will be considering re-evaluation of the sedition law. Until that exercise is complete, the Supreme Court should not adjudicate further. So today, the Supreme Court was supposed to decide whether this is an issue which should be transferred to a larger bench composition, which could go on to finally reevaluate the 1962 Kedar Singh judgment, which was passed by a 5-judge bench composition. Now, in the backdrop of the government's amended position that the executive, in this case the Government of India itself, is going to reevaluate the sedition law, it is a clear amendment of position from what the central government had said just a couple of days back in its affidavit. How the Supreme Court is going to view this, we will keep a close eye on when the matter comes up at 2 in the afternoon today.
Meenakshi, just for a bit of a perspective, tell us on the back of what has this petition come up in the court? You know, there have been allegations of several arbitrary use of this tough sedition law.
Well, yes, that's correct. We have seen a lot of political voices also join in the Supreme Court. We have seen Mahua Moitra, for instance. We have seen yesterday Congress Party make some sharp remarks at the amended position of the government before the Supreme Court. So this is a political hot potato as far, or rather it had assumed the proportions of a political hot potato, because we've seen several state governments also really use this penal provision of sedition, and the primary allegation always has been that this has now become a tool of misuse. It is being used to throttle voices of dissent, and it is used for political witch hunt and vendetta. And that is also one ground that the sedition debate or argument in Supreme Court has really not moved. Because remember that particular affidavit where the government is praying for the retention of the Kedar Singh judgment also came by after a lot of adjournments in the Supreme Court. It was only when the Supreme Court really, raised its eyebrows that how long can the government take to even file a articulated legal response on the issue of sedition, did that affidavit finally really surface. And now after the filing of that affidavit, this is a clear amendment of position again that we are seeing from the government play out in the Supreme Court, which clearly indicates one thing, that a judicial adjudication of this issue for now is being sought to be avoided, and therefore this amendment of position by the incumbent government of India has come by, where the government is altogether seeking for the Supreme Court to keep its hands off the issue. So we saw some reactions come in thick and fast yesterday. We heard from the Congress party. We've seen already TMC speak very vehemently about this, and all other principal opposition parties in
Yes.
India from time to time have spoken about the need to do away with sedition law altogether.
All right, Meenakshi, we'll leave it there for the moment. Thanks very much for joining us with those details. We'll wait and see what happens in the court. Meanwhile, ahead of that hearing, this is what Union Law Minister Kiran Rijiju said.
Honorable Prime Minister Modi ji has clearly stated and directed that we will reconsider and re-examine the provisions of the sedition law. We have conveyed it to the Honorable Court that we are taking a decision. So government's position is very clear, and I hope the court will understand it. And court should not get into this territory of framing laws, because government has already given the commitment.
And former Union Law Minister Ashwini Kumar has also welcomed the centre's move to re-examine the provisions of the sedition law.
Certainly hope that the decision to review the sedition law will be leading to a repeal of this law, and I think this process of review hopefully will not take too long. I sincerely hope that it does not take too long, and that in the process the Supreme Court is not divested of the opportunity to determine the constitutional virus and validity of this very oppressive, archaic and colonial law. In my considered view, this law has no place in free India. The way the sedition law has been abused over the years, and particularly in the last months and recent years, is a compelling argument in favor of the repeal and abrogation of this law.